With this, we'll move on to panel number 3, which will debate on addressing stakeholder challenges in Pakistan's vital industries. This panel shall be moderated by Mr. Noorul Akhtab Siddiqui, who is a director at Tower Bridge Legal based in London, and he will be discussing on construction dispute resolution, specifically focusing on the legal impediments faced by Pakistan's construction sector. Our first speaker in this panel is Mr. Mohammad Najib Harum, who is the chairman of Pakistan Engineering Council, and he will be discussing on the limits and delimits of policy frameworks in Pakistan. Our second speaker in this panel is Ms. Maria Rafiq, who is the Chief Legal Officer of National Transmission and Dispatch Company, Lahore, and she will be discussing on the strategies for dispute avoidance in the power sector. Our third speaker in this panel is Mr. Asim Sumsum, who is the chairman of Abad, and he will be discussing on the role of construction sector in boosting the economy of Pakistan. Our second last speaker in this panel is Mr. Rashid Murid, who is a partner at Sipal & Co., and he will be discussing on emerging disputes in the pharmaceutical and healthcare sector, progression and challenges. Our last speaker is Mr. Justice Asim Hafiz, who is the judge of the Lahore High Court, and he will be discussing the role of effective dispute resolution in enhancing Pakistan's industrial sector.
Ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuh. Honorable justices and ladies and gentlemen, I'm really thankful to you all for taking part in this section of the program. I know that we've had lunch and we've eaten, but now it's time for some food for thought. And I'm very, very privileged here that we have in our panel an extremely illuminated, distinguished panel. And I want to just briefly introduce, very shortly, talk a few minutes about them, and then I'm going to ask each of them to speak to you and give them an opportunity for them to explain their presentation. And then we will ask some questions, and obviously the floor will be open for you to ask any questions as well. On my immediate left, I have Muhammad Najib Harun Saab, who needs no introduction. As you all know, he is the chairman of the Pakistan Engineering Council, which is the regulatory body of all the engineering profession and the construction profession in this country. Professionally, he's been one of the largest construction company owners in Pakistan. So he's got decades of experience, and he has served as the member of parliament at the National Assembly. So we're very pleased that he's joined us here today. Next to him is Ms. Maria Rafiq. She is the Chief Legal Officer of the National Transmission and Dispatch Company. Previously she worked in Abu Dhabi with ADNOC for 8 years. Her background is in commercial arbitration, and she is also the member of the ICC task force for revision on the rules of arbitration. She has also worked with NEPRA. And immediately on her left, we have Mr. Asif Sumsum. He is the chairman of the Association of Builders and Developers in Pakistan, and he is a developer himself, and he will give us an account of the unregulated aspects of mediation that he deals with, and very shortly we'll hear his views as well. Then on his left, we are very privileged to have Mr. Rashid Murid. He is the head of Sipal & Co., which you've seen advertised as one of the sponsors here. His chambers are the first pharmaceutical and healthcare law firm in Pakistan. He's specialized in the field of contracts from Harvard University, and he is the advisor to many multinational and national companies in this field. He's a very proficient advocate in this field, appearing before the High Court and many other tribunals. And then on my extreme left, we have the Honorable Justice Asim Hafiz Saab, who is the judge of the High Court in Lahore, Pakistan. And his expertise obviously is vast. Construction, commercial disputes is his forte. But I have to say, he's an extremely bright and extremely known in the profession for his fairness and his compassion. He approaches his role as a judge with humility and a deep sense of justice. So I'm very, very privileged that we have an esteemed panel here. And I want to ask if I can start with Muhammad Najib Harun Saab to open this discussion.
Well, today's discussion, at the very outset, last 2 days, we have been discussing formal and informal sector to finally put it as per international standard. So, you know, the issues are mainly in the public sector where the public money and public projects are involved. Unfortunately, the private sector has adjusted to it in an informal way. We have with us present Chairman of Abad, and they have also put together informally an apparatus in place to resolve issues because the mechanism in the past, unfortunately, has been so tedious that they resolved to it. As far as Pakistan Engineering Council is concerned, it's only the engineering works and services, which is purely a technical subject. So that is what it deals with. And I will first start with identifying the legal mandate of establishing the ADR Center, because the PEC Act of 1976, which has subsequently been, additions have been made to it, allows us to do 4 things to take care of the problem end to end. The first and the foremost, to establish standard bidding documents all across the country. Of course, to get it implemented, because of whatever culture exists, and there are institutions and some larger than others, some private, some public, they have their own documents, their own contracts. Ideally, the contract document should be one document. Special conditions depending upon the nature of the project, because the projects could be of various magnitude and various, different projects. So starting from highways to dams to high-rise buildings to industrial to whatever. So these special conditions can vary, and that can be listed. So these documents, standard bidding documents, are already, alhamdulillah, are in place, are on the portal. Now the Act mandates to regulate the 2 key stakeholders in delivering the project. The consultant who designs the project, who supervises the quality of the project, and then comes the contractor. In PEC, we call them constructors while we issue them the license. They physically execute the project. So both key stakeholders are given their licenses by the PEC, so the PEC has the control there. It further empowers to inspect the quality of works during the currency of the project, and as to whether they have complied with the standard that was envisaged in the engineering contract or the contract document. Finally, and the foremost, PEC Act, the Act empowers PEC to provide for arbitration in case of disputes in engineering contracts. And here what we have discussed, and inshallah with the ADR in place, so this will be, we'll be trying to deal with the problem in the backyard before it goes to the arbitration or litigation level. So that formally it was inaugurated by the Honorable Chief Justice of Sindh High Court yesterday, for those who were not present here yesterday. So not only we have end-to-end legal mandate which places us in effective position to host the ADR Center and that would be created in all major cities, in the provincial capitals, I would say, and in Islamabad. But we are also guardian of massive engineering expert pool, like I mentioned, that can be utilized as an expert, because lateral inputs, because the areas may be specialist areas, and they vary. There's a broad spectrum, but the pool is there. So these experts, lateral inputs are available with PEC on expert subject specialist arbitrators for making this endeavor successful. Further, PEC's ADR Center is in line with the vision. Now, you know, the SIFC, every day we hear, and we are inviting investors. Any investor who comes to the foreign land wants to see the law of the land, what will happen to their investment. So, you know, if conducive, fast-track remedies are available, they would love to come, because in Pakistan, practically everything has to be done. And there are 250 million people who need everything. There's no infrastructure has finally got to be placed, or everything we are importing. So, you know, the manufacturing has to be put in place. And if one of our friendly countries asks her, okay, friend, tell me what you want to export. Unfortunately, we don't have anything to export at a competitive price to the world who is ready to receive products from us. So all this will happen, foreign investment will come, and I'm sure the realization of, and the presence of our judiciary, high judiciary, and the interest of, you know, the Chartered Institute of Arbitrators, because PEC has been doing all this, but now with this patronage and the and in totality end-to-end solutions, inshallah, Pakistan is ready to receive the foreign investment, and we will do it on a priority and on a yesterday basis, inshallah.
Thank you. Mashallah, that was very interesting. And I'm going to come back to you asking a few questions in some of the issues that you raised. But from the power sector, can I ask Ms. Maria Rafiq to give her presentation, so that then we can ask you some questions as well.
Okay. Thank you, Noor. It's an absolute honor to be sharing this stage with this esteemed panelist, and especially with His Lordship Justice Asim Hafiz, and also Justice Jawad Hassan, who's also my teacher in the law school. So my subject is to how we can avoid disputes in the power sector. So first, let me begin with that I am working with NTDC, National Transmission and Dispatch Company. So we have to first understand like what sort of disputes we have in NTDC. It's related to construction, although I've been told in the morning that, you know, I'm representing the whole power sector perhaps to identify their issues, which I can slightly touch upon because I work with the regulator as well now with the NTDC. So basically we have construction sort of disputes, the major ones. And before coming to this conference, I spoke with our concerned contract department, and I asked them like, you know, what sort of issues we are having with the contractors on a daily basis. And I was amazed to hear that, you know, in their contract documents, they are quite outdated. And, you know, we do follow FEDEC terms and conditions, but, you know, since yesterday, I've been hearing about this dispute avoidance and adjudication board concept, which we don't have in our contracts. And I was not surprised to know this because in one of the presentations, it was mentioned that only 7% of people know about this DAB concept. And I believe that, you know, if DAB concept was incorporated in our contracts, I believe the litigation and the arbitrations that we have to gone through in the past would not have happened in the first place. Secondly, you know, so the question is what sort of disputes can be avoided? So any disagreement, it basically all matters can be avoided. So dispute basically is any disagreement among the parties. I'm not giving the legal definition, but from the layman's perspective, any difference of opinion, any disagreement from the terms and conditions which the parties have agreed upon, they can have a dispute later on. Now, to understand, like, how the dispute can arise, like, first we need to understand the public sector. What I feel is the problem is that, the contracts that we are executing, they are not well negotiated. I have noticed that most of the time parties don't even know what they have agreed upon, and I totally agree with the Mena's presentation yesterday. Like, it's so much important that, what you're going to implement, you should aware of it first. So the breach will, it's inevitable that, the breach will not happen because you don't know what you have agreed upon. So the first thing is that the contracts need to be well negotiated, the scope is well defined, because what happened in the construction disputes is that we are in a rush and we have so many projects and we're just signing off those contracts, and later on we realize that it doesn't cater our whole requirement. And then we have to amend that scope, and that results is not just a written one-liner amendment, it has a consequence in terms of claims that we receive, and in order to resolve those claims, it takes months and months, which eventually delays the project. So, so I feel like, DAB is the solution, as I can see that, we need to introduce it in our contracts to avoid those disputes. And also, if we include this sort of mechanism, like, so there, I think Shahab Saab in the first panel explained the benefits of DAB, and from the lawyer's perspective, he actually covers all what I wanted to say, because, as an in-house counsel, my approach is that, of course, we can't end up litigation. There will always be a party who is aggrieved. But I want to focus more on doing things which can improve the performance of the department in terms of formulating those policies and procedures which the company employees should follow. And unfortunately, the problem in the government sector is that, sometimes the guidelines exist, but nobody is following them because they don't know where they exist. We sign off the contracts and we put it in a shelf where we do not see them during the project life. We only open that document when the dispute arises, and they leave it up to the lawyer to find out a solution for them. As they say that, when the dispute arises, contract is the king. So we need to first put an effort, the efforts we usually put in to resolve the disputes, we should put that effort in negotiating that contract well. We should have a panel of experts from all fields, technical, legal, and commercial, who assist internationally and locally. We should benefit from that. We should not just benefit from the foreign lawyers in defending us in the arbitration disputes, but rather than we should get their expertise in getting our documents in order. So this is something that we need to in the public sector have to look for. Second, in the power sector perspective, there is there should be clear responsibilities of the departments what they have to do. I feel like there is quite an interference from other departments. Everybody has clear set of roles and responsibilities under their if there's a company or it's a statutory body, they have their own role to play. So instead of doing their work, there is so much interference in others' work. Our decisions of the departments are made somewhere else. So obviously, we have to, and we are just sometimes other rubber stamp, like, a decision has been made and we have to endorse it. It's very important that, we should be made part of that process of decision making when the decisions are made for us, and that can avoid many disputes in the future as well. Because in one of the, I think Sheikh Muhammad Ali has mentioned about the treaties, etc. So even in that contract, if we have referred any quality standards, let's say, or any engineering standards, treaties that we have signed for. So we have to comply with those terms and conditions, and have to get our, there should be a capacity building of the employees that, you know, it's a legal binding document and we have to comply with. This is something which I feel in the government sector we are not, we are lacking in that area. It's not everything is there, the laws, rules and regulation, but it's just the will to basically execute those guidelines, terms and conditions, regulation, etc. Do I have it?
Thank you so much. Thank you. That's very interesting. And again, I've got a few questions for you, which I'm going to ask, come back to you. But from the pharmaceutical industry, I would like Rashid Murid Sahab, if you can just enlighten us from your perspective, that'll be very interesting.
So with the Pakistan market, the value of around $5.5 billion, this all happens back in 2012, where the PIC tragedy was occurred, with more than 250 patients who died in Punjab. And right after this, Honorable Supreme Court took suo motu notice, and subsequent to that, the government of Pakistan made a body called DRAP, under the DRAP Act 2012. So this is all started from here with respect to the emerging disputes. The mandate of the DRAP is to adopt the regulated market regulations here in Pakistan. So recently that we have seen the current regulation with respect to the contractual disputes. This is very normal in the pharmaceutical sectors of the contract manufacturing, and used to term here in Pakistan called the toll manufacturing. The main issues involved with respect to the toll manufacturing is the delays in manufacturing and the raw materials, or the manufacturing with the different specifications. So these are the key issues, the linked with the toll manufacturing side. This was very uncommon back in 2018, but after the amendment in the policy of the contract manufacturing, now the foreigners and the foreign companies and the local companies who have expertise in promotions and marketing and distribution, they can get product manufactured from the big companies, from the manufacturing company. But this is the the main issue with respect to the the delays in the manufacturing, and also the government regulation with respect to the quality, safety and efficacy of the products. Second thing is with respect to the the data integrity and the data management. The pharmaceutical sector is in what kind of I must say the research and development of the medicine that take the years and years. So the data management is very critical for the pharmaceutical industry. Now the regulations are here in Pakistan to get the product registered with the dossiers here in Pakistan, to have the bioequivalent studies from the CROs, called the clinical research organizations. And we have seen the disputes with respect to the CROs and the DRAP, and also the manufacturing units who want to get registered product from the DRAP and to the Pakistani market. So the clinical protocols, the deviation, the patient infrastructure, the patient the usage, and the confidentiality clause, these are the main key areas that we have seen the companies facing challenges in terms of settling their dispute with the CROs. The second and the most important here in pharmaceutical sector, which is quite unnormal with respect to the acquisition and merger as compared to the other industry, including in Pakistan and the worldwide. In the 3 days back, as we heard, the LCI has acquired the Pfizer Pakistan, USA and Pakistan. The acquisition, the main disputes involved in the acquisition, because we have seen in Pakistan last from 20 years that more than 50 multinational companies has been acquired because of many commercial reasons. But the thing is how to transfer their assets to maintain the business continuity, and also with respect to the transfer from the government side. And I must quote here the Honorable Justice, Mr. Justice Shafi Siddiqui Saab judgment, which recently has been passed with respect to to have to settle the dispute with respect to the NOC from the the party here who have already terminated their contract, who has have no right to get the NOC from the terminating party. This is what has been set aside by the the Sindh High Court, and subsequently the DRAP has adopted this and the judgment and enforced by law. And also with respect to the acquisition and merger, the CROs. Here in Pakistan, we have seen the government in last 5 years, government has given many, the license to the semi-government, the government, and then the private parties, the license to the various CROs to conduct clinical trials of the various manufacturing companies here in Pakistan or in the abroad. And the third and the main, the issue is supply chain and the drug shortages. We used to, we hear all the time in the news and media that the products are already short. To some extent, it's a good reason from the pharmaceutical industry. Like we 95% dependent on the raw material we import from China and India and other countries. So we are totally depending on the raw materials, and we have seen a couple of challenges last in COVID eras, and we are dealing with some arbitration and the dispute which arose back in COVID eras with the Chinese companies or in the Indian companies or Taiwanese companies. And the last and the most important, which what I have seen in Pakistan and internationally, is the IPR rights of the pharmaceutical industry. So the IPR rights is mostly driven by the pharmaceutical and the healthcare sectors. Here in Pakistan, as we know, the Pakistan pharmaceutical industry is a generic-driven based industry. The moment product launch in US or in European market, next day the manufacturers of Pakistan are also able to manufacture here with the prior approval from the DRAB. Now the point is how to maintain their, the patent laws and the trademark and other things involved with respect to the IP laws. Apart from the government enforcement and the government actions, now the big companies are having the originator brands internationally. They come into the agreement with the exclusive agreement and the royalty based model with the pharmaceutical companies here in Pakistan, internationally. And we have seen last from 5 years time where the IPR regulations is not much more imposed and settled by the parties or in the court of law. The most of the Indian companies have breached their IPR, the regulation with respect to the manufacturing of their raw materials have been already patented in US or in the European Union. This is the main reason here in Pakistan as well with respect to if you file a dossier of the generic molecule or the formulation here in DRAB, the DRAB, what their stance is, see, this is a generic formulation and we are the technical authority. If someone files dossiers to us, we will definitely approve it. And if it's a challenge with the patent or the trademark, you have another authority you can go and fight. So the pharmaceutical industry, who have the champion in the R&D businesses, they have agreement with the pharmaceutical company, and also they face some problems in terms of the financial transactions and the contract performance and the delays in terms of the implementing their the conditions at the shop floor. And secondly, with respect to the the hospital industry, which is an emerging field here in Pakistan as far as the disputes are concerned. Why I am asking this? Because the last from 75 years, the hospital were not used to with the regulations, even the doctors and the clinics and the paramedical staffs, because of so many reasons. But after 18th Amendment, the Healthcare Commission has been established at provincial levels, and we have seen last from 5 to 7 years time, all the provincial healthcare commissions are actively enforcing their regulations. And to this, what we have seen, the contract between the physician and the hospitals. This is the unique model that we have seen in various big hospitals and the mid-tier hospitals. The doctors have their payroll on the hospital and they have contract with each other. If any of the party aggrieved, the patient aggrieved by any of the hospital facility or with the doctors, they blame to each other, and that ultimately went to the court for the settlement. And the second thing is the insurance company with respect to the reimbursement and other charges and the admission policies, and they have with respect to the banking sector and also with the hospital sectors. And the second last is the medical malpractices and the complaints. We have seen the unusual trafficking of complaints in urban areas. Because of the people awareness and because of the regulations and because of the the media campaigns by the healthcare commissions, the people do file the complaints in hospitals, which we have seen the patients aggrieved with respect to in terms of treatment, in terms of finances, in terms of the overall service delivery system in the hospitals. So whatever the reason is, they filed complaint into the hospitals, and the challenge is how the hospitals satisfy their complaint, having they have the agreed party with the hospital, and the next forum is the Healthcare Commission, and also the Healthcare Commission laws is somewhat is to penalize the hospital or the doctor or the clinic, and ultimately matter either of the party went to the district and session court and then the high court. And the last is the malfunctions claim, the outsourcing. As we have seen in the hospital industry, the mostly run by the the medical equipments and the other equipments and surgery equipments, which are linked with the contracts and the agreements. And we have seen, as usual, the conflicting point of view with respect to the medical devices industry, pharmaceutical, and the paramedical staff that create some challenges. And I have experience with the pharmaceutical and hospital industry. So this disputes may arise manifolds in next few years' time. And yesterday we have seen Mr. Sharaz and Honorable Justice Mr. Jawad Hassan Saab has briefed us about the Arbitration Act draft, about the Arbitration Act of 2024. That will definitely help us in terms of settling healthcare disputes. Thank you.
Thank you for that. Just before I ask Mr. Asif Samsam to say a few words, I'd like, from the judicial perspective, Honorable Justice Asim Hafiz Saab to say a few words on this occasion.
Thank you for having me here. My topic today is actually the role of a dispute resolution in enhancing the industrial sector. I mean, there's no cavil about it that we have been discussing for over 20 years now. What is the role of DR in otherwise helping in bringing back the confidence of the investor and in helping to actually expand the industrial base? What is the punchline? Is it how effective should be the role? There are a couple of factors which I need to discuss. We have infrastructure, we have laws, we have mediation, we have boards, we have arbitration, we have other infrastructure. But what we lack is we need to influence the thinking actually. This entire conference, the efforts to persuade people to resort to mediation, arbitration, or other dispute resolution mechanism is actually to facilitate a common man, a person, a client in the context of a lawyer. Now, the most important part is I've been practicing at the bar. The most problematic issue is whenever a client comes to you, they would never actually speak out the true facts. That actually is the problem, because unless they speak out true facts and bring the complete fair picture before you, you cannot actually advise them to an arbitration or so whatever the mechanism would be, unless we influence the thinking of a subject, which is a person who is actually raising a dispute, we can't make an effective inroads into this. The second is the role of the judiciary. I think I've been hearing for so many of participants, judiciary has never actually discouraged mediation, arbitration, or any other enforcement of a dispute resolution mechanism. They've already encouraged that. The only problem is that what we need to distinguish is that judicial inclination to facilitate mediation or arbitration is one thing, and the availability of time and resources to deal with the disputes another thing. I think what we need to do is we need to concentrate on the latter. It's only a question of time that what we lack is in deciding a commercial dispute or commercial or any other dispute. Now, over the decade, I think judiciary has been showing restraint in involving in a pre-tendering dispute, post-tendering disputes, issues regarding mobilization advance guarantees, issues regarding performance bonds. I think that is an efficient participation of a judiciary to actually persuade the parties to come to resolve their disputes. Now, one cannot actually eliminate a role of a judiciary. Judiciary has to play a role of a big brother actually, which has to supplement and support the effort of this dispute resolution mechanism. And perhaps what I think is we always encourage this alternate dispute mechanism should prosper actually. And I think speaking for myself and all other judges, our work is evident in terms of the judgments available. And as we have, most of the judgments have been referred, they are always for the pro-enforcement. I mean, it's very encouraging that the foreign international awards are being enforced quickly now. I have a slight difference, The difference is that we have criticized the Arbitration Act 1940. What I think is law is not a bad or a good actually, it's how you enforce that. And the enforcement problem is actually with the courts exercising general jurisdiction. It's not the courts exercising special jurisdiction actually. What we need to do is to make it clear to a civil judge actually that everything does not come within the ambit of Section 9 suit. There are other laws and it has to be respected. So if the first day if a suit is filed, the mechanism is available, Section 34 applies to that. But how he looks at it and how he applies, that's the question actually. I agree with that there's a lot of delay in deciding application under 34, application under Section 20. But then even if we look at the Arbitration Act across the globe, judicial intervention is there to an extent. So what we need to understand is that judicial discretion, judicial intervention is there, but it has to be exercised cautiously. And one more thing I want to add is that we have discussed a lot about it, this mechanism, laws, judiciary, lawyers. What we need to understand is yesterday there was a discussion that lawyers should actually encourage mediation. What we need to think is we need to actually draw a distinction between lawyers sitting, having an office in a Clifton, lawyer having an office across the High Court in E. Plomer building, and a lawyer who is actually doing practice in Bahawalpur, who is actually doing practice in Multan, in Jakpabad actually. I mean, a lawyer working in Bahawalpur will charge the fee for a family suit, say about 50,000. You expect the lawyer to advise his client to go mediate and give up 50,000 rupees. I mean, it's quite easy for me to sit in a chamber in Lahore and refuse a family matter because I know I have no time for a family matter. But lawyer sitting in Bahawalpur would not refuse that brief. So I think we need to keep that context in our mind while making all these efforts in it. Thank you.
Thank you. Undoubtedly, this whole concept of mediation and arbitration, I'm coming from an outsider from the UK as a practitioner. I have to say that to see the amount of judicial support and the amount of judges that you've seen here and in all the events, and especially the contribution of people like Justice Jawad Hassan and Sayyid Mansoor Ali Shah Sahab, who really go out of their way to try and encourage and to tell the world that Pakistan is taking mediation and arbitration really, really seriously. And what's encouraging is to see so many judges here giving their support on this occasion. Just before I ask the panel some questions, I wanted to ask Mr. Asif Sumsum. He doesn't speak English very well, but we all understand Urdu and we all understand Punjabi. But I want to ask him, because he is the chairman of the Builders Association and of developers and builders, and obviously dealing with a lot of unregulated matters. सो आसिफ साहब, मैं आपसे क्वेश्चन ये पूछूंगा कि आप जो हैं वो चेयरमैन हैं एसोसिएशन ऑफ बिल्डर्स और डेवलपर्स के, तो आपकी जमात का क्या रोल है इस मीडिएशन के अंदर?
हाँ, बहुत शुक्रिया आपका, आपकी पूरी टीम का। और मुझे बड़ी खुशी है कि इतने अहम इवेंट में आपने हमें मौका दिया। मैं आईक्रेब का भी शुक्रिया अदा करता हूँ। मैं आपकी पाकिस्तान इंजीनियरिंग काउंसिल का नजीब हारून साहब, आपका भी मैं शुक्रिया अदा करता हूँ। और ख़ास तौर पे मैं अदलिया का, सिंध हाई कोर्ट का, कि मुझे बहुत ही खुशगवार हैरत भी है और मैं समझता हूँ कि ये हमारे फ्यूचर के लिए भी जो हमारे माशी मुश्किलात हैं उसके लिए भी ये आज की नीड थी कि आर्बिट्रेशन के हवाले से इस आर्बिट्रेशन की हैसियत को तस्लीम किया जा रहा है। और मेरे कुछ दोस्तों ने भी ये बात कही कि आर्बिट्रेशन एक्ट की बात हो रही है, तो मैं समझता हूँ कि जब तक आर्बिट्रेशन एक्ट को हम मजबूत नहीं करेंगे कोई भी मईशत, मैं बात इसलिए मईशत से शुरू करता हूँ कि अगर मईशत ठीक नहीं है तो सारी चीज़ें ख़राब हो जाएंगी। आपकी अदलिया पे बोझ भी बढ़ेगा, लॉ एंड ऑर्डर की सिचुएशन भी ख़राब होगी, और ये जो क्राइम का जो रेशो बढ़ता जा रहा है ये भी लिंक है हमारी मईशत के साथ। और मैं आज थोड़ा सा इंट्रोडक्शन एसोसिएशन ऑफ बिल्डर्स एंड डेवलपर्स ऑफ पाकिस्तान का मैं आपको देता जाऊँ कि हमारा ये जो एसोसिएशन है ये आज अपने 50 साल से ज़्यादा इस मुल्क में यानी गोल्डन जुबली अपनी ये मना चुकी है। वो पूरे पाकिस्तान में ये सिंगल प्लेटफॉर्म है बिल्डर्स एंड डेवलपर्स का, रिकग्नाइज और कानूनी प्लेटफॉर्म है। इसके अलावा कोई प्लेटफॉर्म नहीं है जो बिल्डर्स को पूरे पाकिस्तान में रिप्रेजेंट करता हो। और 1400 से ज़ायद हमारे मेंबर्स हैं। और वर्टिकल तामीरात की जब हम बात करते हैं तो कराची, सिंध की जब हम बात करें तो सिंध में कोई भी वर्टिकल तामीरात हो ही नहीं सकती अगर वो एसोसिएशन ऑफ बिल्डर्स एंड डेवलपर्स का मेंबर नहीं है। और इसी तरह हम कोशिश कर रहे हैं पाकिस्तान के दूसरे शहरों में भी, चूँकि रिवाज नहीं है, लाहौर में, इस्लामाबाद में वर्टिकल तामीरात का बहुत कम रुझान होता है, तो वहाँ भी कोशिश कर रहे हैं कि CDA, LDA में जो बायलॉज बने, मैं थोड़ा सा इंट्रोडक्शन इसलिए दे रहा हूँ कि मैं आपको अपना कंट्रीब्यूशन बता दूँ कि एसोसिएशन का क्या कंट्रीब्यूशन है। कि LDA में जो नए बायलॉज आए या जो भी चीज़ें आई तो वो हमारे नॉर्दर्न के चेयरमैन, एसोसिएशन चूँकि पूरे पाकिस्तान की है, एक नॉर्दर्न रीजन है, एक सदर्न रीजन है। नॉर्दर्न का चेयरमैन पंजाब और KP के को सुपरवाइज़ करता है, तो वो LDA में एज ए वाइस चेयरमैन LDA के वो थे। तो ये जो सारी जितनी भी रिवोल्यूशंस आई हाई राइज की, मैं ख़ास तौर पे बता रहा हूँ, लाहौर में ये हमारा ही चेयरमैन था जिसने ये सारी बायलॉज के हवाले से जो काम करना था वो उसको किया। और हम जब बात करते हैं कि हमारा टैक्स में शेयर कितना है, तो मैं बात नहीं करूँगा कि हमारा इंडिविजुअल टैक्स में शेयर कितना है। मैं बहुत सिंपल एक फार्मूला बताता हूँ कि जो कराची में जो बायलॉज आज सिंध बिल्डिंग कंट्रोल अथॉरिटी के जो सिंध की पूरी रेंज में हैं, उसके बायलॉज के तहत अगर मैं 1000 गज का यानी 75 इंटू 120 फीट की डायमेंशन के एक प्रोजेक्ट पे काम करता हूँ तो 800 मिलियन रुपए की लोकल इंडस्ट्री से ड्यूटी पेड गुड्स में कंज्यूम करता हूँ। मैं पास ऑन नहीं करता, मैं उसको सेल आउट नहीं करता, मैं उसको कंज्यूम करता हूँ। ये सिर्फ 1000 गज के प्लॉट की हमारी स्ट्रेंथ है। आप अंदाज़ा लगाएं कि पूरे पाकिस्तान में हमारी क्या स्ट्रेंथ होगी, कि लोकल इंडस्ट्री में कितना बड़ा कंट्रीब्यूशन होगा। और एसोसिएशन ऑफ बिल्डर्स एंड डेवलपर्स को अल्लाह ताला ने ये एजाज़ दिया है कि मिलियंस ऑफ जॉब का अल्लाह ताला ने उसको प्रोटेक्टर बनाया अपने शोबे के हवाले से भी, और जो 72 अलाइड इंडस्ट्री मेरे साथ लिंक कर रही हैं उनके हवाले से भी। और हमारा चूँकि ये इतना बड़ा फोरम है, और मैं फिर शुक्रिया इस टीम का अदा करता हूँ कि मुझे मौका दिया है बोलने का। तो आर्बिट्रेशन के साथ मैं ये बात कहना चाह रहा हूँ कि अगर हम किसी ऐसे फैसले पे हुकूमती जिसकी वजह से काम मुतासिर होता हो मुल्क में और हमारी इंडस्ट्री में काम रुकता हो, अगर हम उस पर कानूनी एहतिजाज ना करें तो वेरी नेक्स्ट डे इस पूरे शहर में घूम के देख लें, हज़ारों की तादाद में मजदूर बेलचे और कुदाले लेके चौरंगियों के इतराफ़ में आपको नज़र आएंगे। इतना फास्ट रिएक्ट करता है ये शोबा, और हमारा ये क्लेम है कि ज़राअत के बाद सबसे ज़्यादा जॉब प्रोवाइडर जो स्किल और नॉन स्किल लेबर को जो जॉब प्रोवाइड करता है। आज आप मुझे कोई नॉन स्किल लेबर अभी मुझे भेजे, मैं अभी उसको जॉब प्रोवाइड कर सकता हूँ। तो अल्लाह ताला ने ये एजाज़ दिया है इस इदारे को। और चूँकि बात वीकेंड है आपका इंटरनेशनल डिस्प्यूट रिजोल्यूशन के हवाले से, तो मैं आज अपने सेक्टर के हवाले से मैं बता दूं कि पिछले कई सालों से सबसे मजबूत आर्बिट्रेशन का इदारा हमारे पास है। सबसे ज़्यादा आर्बिट्रेशन हम हमारे इदारे में करते हैं। हम चूँकि अपने सेक्टर से मुताल्लिक बात कर रहे हैं, और हमें ये बहुत अच्छे तरीके से अंदाज़ा है कि इस वक्त भी कोर्ट्स के अंदर, अगर ख़ास कर मैं सिंध हाई कोर्ट की मैं बात करूं, तो सबसे ज़्यादा जो केसेस जो इल्तिवा हैं या जो दायर होते हैं या प्रोसीड के उसमें हैं, वो सबसे ज़्यादा हमारे सेक्टर से मुताल्लिक वो केसेस हैं। और हमारा ये कहना है कि अगर हमारी आर्बिट्रेशन को कोई कानूनी फ्रेमवर्क, जैसे कि आज आर्बिट्रेशन की बात हो रही है, तो चूँकि हमारी एक्सपर्टीज़ हैं, आज अभी जिक्र किया नजीब हारून साहब ने कि जो इंजीनियरिंग कौंसिल है, वो ये सारे लोग हमसे सारे लिंक हैं, और हमारी ख्वाहिश होती है, और हम हमेशा इस बात पे ये भी मुत्तफिक हैं, हम भी मुत्तफिक हैं कि जब किसी प्रोजेक्ट के हवाले से या किसी भी मामले में डिस्प्यूट क्रिएट होता है, और अगर वो मामला अदलिया तक जाता है, तो हम सिर्फ ये रिक्वेस्ट करेंगे, क्योंकि अदलिया के लोग भी हैं, और हम एक पाकिस्तानी, एक मुहिब्बे वतन पाकिस्तानी होने के नाते एक रिक्वेस्ट हम ज़रूर करेंगे आपसे कि ज़्यादातर जो आर्बिट्रेशन हम करते हैं, उनमें ज़्यादा केस वो होते हैं जो बहुत ज़्यादा प्रोलॉन्ग हो चुके होते हैं, या हम समझते हैं कि डिले हो चुके होते हैं, तो वो डिफ़ॉल्ट की तरफ प्रोजेक्ट चले जाते हैं। तो सर, तो अगर उसमें कोई इन फैसलों में कोई थोड़ी सी तेज़ी हो जाए, या हमारी तरफ ये जो डिस्प्यूट के हवाले से जो मैटर हैं, अगर हमारी तरफ भी रिफ़र कर दिए जाए हमारे सेक्टर के हवाले से, तो मैं समझता हूँ कि बहुत आसानी होगी। और मैं रिक्वेस्ट ही कर सकता हूँ इस हवाले से, क्योंकि बिलियंस ऑफ रुपीज़ की इन्वेस्टमेंट हमारी स्टक हो जाती है। और इसी तरह जैसे मैंने 1000 गज की डायमेंशन पे आपको बताया, तो इतने बड़े साइज़ के जो प्रोजेक्ट्स हैं वो जब स्टक हो जाते हैं, तो मुल्क की इकनॉमी में भी बड़ा मुश्किल होती है, अलाइड इंडस्ट्री को भी और लोकल इंडस्ट्री को भी। और इसके अलावा सर, तो और ठीक है सर, मैं इसके साथ बात ख़त्म करता हूँ, लेकिन फिर मैं शुक्रिया अदा करता हूँ आपने मुझे बात करने का मौका।
बहुत बहुत शुक्रिया, थैंक यू फॉर दैट। We only have a few minutes left, and I really want to ask one or two questions to the rest of the panelists before we finish. Directing the question back to Najib Saab, Pakistan Engineering Council is working with the federal government, and you've created a think tank. I'd like you to just to tell me what the objective of the and the role of the think tank is, and then if you can include that with your final question I want to ask you, what is your vision for the Pakistani Engineering Council? What is its vision for the construction industry? I know it's going to be short but sweet. Yes.
Great. Alhamdulillah, the PEC Act has been is quite comprehensive and covers, like I said, end to end. The part that I love most is that there is a function of through the PEC Act, which says that PEC will assist the federal government as think tank. Through that function, what we do is provide scientific studies to the different ministries of the federal government, where these are specialized studies related to energy, related to water, related to infrastructure, and sometimes agriculture. So all these studies are done by PhD professors, specialists, under the auspices of Pakistan Academy of Engineering, whose fellows are minimum like PhD people who finally sign them out, the studies, and give them to us so that they are given to the federal ministries for implementation. So that's one. like I said, standard engineering contracts. Because this is a proactive thing.
Sure.
It's been this was delegated to us since 1992. It's ongoing, and like I mentioned, that already now it is aligned with FIDIC 2017, which reduces the timeline. So that is there. Like the price adjustment formula is a major contribution of PEC. Why I say that? Now, of course, all of us know that in our country, every fortnight, the fuel price is adjusted. And that directly hits the cost of energy or all the freight, all the, everything around, from electricity to everything. So that influences the end price. So that takes care of that. So the price adjustment formula is sensitive both ways. If it goes upward, it reacts. If the prices for some reason, whether for petrol, etc., goes down, again it reacts immediately. So this is price sensitive, and so that the project keeps breathing and keeps moving. So this is so important. Similarly, like the green building thing that we are hearing all over the world, Pakistan has a very small carbon footprint, but we get a major hit. The floods, flash floods from 2022, we are still dealing with that. So by the International Code Council out of USA, I was there in Dubai with Dr. Sarosh Lodhi. We got an award in that. Now we are working towards the implementation of the same, and the resource pool that I keep mentioning, that is working day and night through the committees to upgrade the Pakistani industry and system outright. The fight against energy, the energy future of Pakistan is the most sensitive issue, and I think that whatever effort PEC is doing, that must synergize with the rest of the departments which are working on that, because the cost of energy is so high that it's not possible for us to even compete with the imports that we are having. Because when we produce those same products with that high energy cost, we are not competitive. So we love to import everything from China, and that's taking toll on the country. We can't afford that. So low-hanging fruits, we must start, and I would allow me to say that reverse engineering, maybe we need to do for some years shamelessly, because now we cannot afford. So those products we need to produce. If we are importing 200 items, or at least 50, 60, 70 immediately as of yesterday, we have to work towards that. And like now I come to the last part of your question about the construction industry. Even today, construction, which is the backbone out there of any development anywhere in the world, is not recognized as an industry in Pakistan. So recently, finally, through a lot of ordeal, the Planning and Development Ministry has delegated this task again to Pakistan Engineering Council to put together the Construction Industry Development Board in a formatted way. So we are in the process of developing that, so that the CIDB will prescribe the standards for design, construction, and it would be accepted in the banking sector and in other sectors as a recognized industry. It has to be disciplined, it has to be regulated, and once that happens, it will turn, like our friend from Abad said, that any country in the world that has turned into a developed country, the wheel of construction is the forerunner, is the front runner to move, and once that gets going, the country starts going upwards. And I think Pakistan, as soon as we can sort out our energy crisis, the energy mix, and then go on with the development, we will be in the run. Thank you very much, sir.
That's very kind. That's very interesting, and I'm sure that a lot of people will be asking you questions later, undoubtedly. We've got a few minutes left. I just want to turn back to Ms. Maria Rafiq. You said very interestingly, and we heard today, that NEPRA is still in the process of learning and developing its experiences. But you as a licensee, how is your experience with the power regulator? That's what I want to ask you, because obviously, being a licensee, you have your own experience.
Well, briefly, what Justice Zulfikar said, that the regulator surely needs to be regulated. Because I think what happens is that as a licensee, I have a contract with the regulator as well, because my terms and conditions are set out in the license. Now, regulator role is not just to penalize the licensee. Their role is first to monitor the license which they have given us, and throughout the process, they have to have, like, you know, these regulations and the guiding principles, our performance standards, they have to be implemented throughout that process. But what's happening is that we are just being penalized by, you know, huge fines, and, you know, it's like, you know, they wait for that something happens and then they have to penalize us. We do understand that the NEPRA generates revenue through fees and fines under their NEPRA Act, but that doesn't mean that the licensees are just meant to be, you know, to be fined with these, if they have set out the non-compliance standards clearly. So, so obviously our experience is not very pleasant, basically because, you know, what happened is that NEPRA, and I give one example for so we have a fuel cost adjustment hearing every month. So under Section 31 of the NEPRA Act, it says that, you know, if there are any fuel variations in dispatching power from the plants, then they have to follow economic merit order. Now, if that merit order is not followed, then obviously there are deviations from the provision of the grid code that is the Bible for NTDC to as a part and parcel of our license. What happened in the past 5-6 years since 2019? Instead of, let's say if they wanted to penalize us, if there was any non-compliance to it, they had a chapter of investigation and then they had to show cause us and penalize us accordingly. But they penalized us by withholding amounts from our revenue. Since 2019 until date, it has, the amount has accumulated to 42 billion. Now, we approached, so if the question being asked, like how we are being regulated, well, regulator is regulating us by sending us from one forum to another. If we are in the High Court, because, you know, one of the panelists mentioned that there is no member finance in the NEPRA tribunal, now we went to the, in the writ jurisdiction, and the NEPRA has not given a single statement on the merits, but all what they have asked the judge was that, you know, they should be remanded back to the NEPRA tribunal, and they didn't have the jurisdiction. Okay. So these are the issues, like, you know, and for the past 2 years, our tariff petition is pending before the for the tribunal. And the last tariff we received was 2022, and still our tariff petition has not been fixed before NEPRA. And the user system charge we have been charging is 235, and now it has gone up to 400, but we are still imposing the tariff of 235. So, you know, these are our challenges with the regulator, but, you know, as I say, the lesson is not learned until something changes, and we need to really, you know, engage all these stakeholders if we really want to improve the power sector. And the most important thing is the governance. We have to put the right people on these positions, and by right people, I mean on merit, not based on political choices. Thank you.
Fantastic, thank you. Turning to you, Maritza, the question I want to ask you is, within your field, should the arbitrators be from the healthcare and pharma sector, or can they be from a wider field?
See, in pharmaceutical contracts,
if you can speak closer to the mic.
Yeah. In pharmaceutical contracts, there are 3 main clauses. One is the technical terms, because it's a highly technical, you know, the industry. And the second is the commercial terms. And third, of course, the regulations. It's a highly regulated industry and the regulatory terms. But as per my experience, that what we have seen, the most of the dispute, you know, comes from the pharmaceutical side is the technical terms, in terms of interpretation, in terms of drafting, in terms of performance of the technical obligations. So for me, that is, the most important thing is the person, the organization who is drafting, apart from the legal knowledge and on the contract side, but must have the technical knowledge as well. And the last point, what I observe that has not been covered so far in yesterday and in today as well. What we have seen with respect to the pharmaceutical sectors, probably here in Pakistan, the regulation is also the contributing factors toward the commercial disputes.
Yeah.
Why I'm sharing this, the draft adopted the regulation of the highly regulated market, the US FDA or the European Union and the ICH, which actually is not practical here at shop floor here in Pakistan. It's an ongoing process to implement it. With respect to the controls over the commercial terms between two organizations, the draft have certain conditions. The government have certain obligations to meet both the parties, which is nothing to do with the quality, safety, and efficacy of the product. That also, the contributing factors in terms of the disputes. So, so my, the take is the technical knowledge is, the most important thing while drafting, the contract, that, avoid, the disputes and then the other things.
Thank you so much. I'm going to open the floor for any questions. We've only got 5 minutes left, and I'm conscious of the fact that we want to finish on time. Are there any questions? We've got distinguished panelists, say, from different sectors, and I think that here's your opportunity of asking them any important questions anybody has. If there's no questions, I have plenty of questions. There's the gentleman there, if somebody can pass him the speaker.
Hi, my name is Adil Lalani. I'm a litigator, disputes resolution practitioner at Heather Wahid Partners in Karachi. And considering that we have such a diverse array of panelists here and from different industries, what it seems to me is that a particular problem is with technical expertise in disputes, as you just mentioned right now with regards to the pharmaceutical industry. And my question is, how do we ensure that we have sufficient enough capacity building measures in place to tackle both the legal aspect of these disputes as well as the technical aspects, apart from the usual structuring of these dispute boards or these tribunals with experts on each side? Is there a way that we can structure a combined expertise in order to avoid such technical disputes from arising in the first place, perhaps through proper contract administration or other such measures built into the safeguarding initiatives within these industries? Thank you.
Najib sir, would you like to?
Yeah, because there is a technical side to it and of course the legal side to it, and that's where the both inputs have to combine actually. So the alliance, I would say, or the MOU, the understanding with the Chartered Institute of Arbitrators, UK, is that they would be training, arbitrator persons into this specialized field, so they would have that certification and competencies, technical combined with these legal, so that they can sit down and settle issues in a comprehensive and holistic way, and on a fast track basis, in a shortest spell of time, because most contracts, because of inflations, etc., the prices, the reference things keeps changing, and this is how I'm sure most countries, developed countries in the world, have taken off, and I'm sure today we are on the runway. Hopefully we will also take off.
Thank you. That's a very good response. Any other questions that we have? Yes, a question here at the front.
Yeah, my name is Nevin Merchant.
Yes.
And my question, I don't know who will answer that, but there was very good discussion on dispute resolution. What I want to know is that, are we talking about mediation or are we talking about arbitration or any other mode? Because there was no clarity. Now, mediation and arbitration are both poles apart. So I want to know from Najib Harun Sahab that, what is the thought behind it, and in the contracts, do we add the mediation clause as well?
Yeah, basically, the last resort is the litigation, and ahead of that, the arbitration. and mediation, etc. In this particular case, you know, the 2 days that all this, you know, discussions have been majorly about dispute avoidance to begin with. You know, all fires which get big, you know, are initially small fires. So if they can be controlled at an early stage, they won't turn into those, you know, jungle fires and take, you know, all the profits and all everything. You know, actually the end user of the project, when the projects get delayed, the gainful utilization of the projects, because if a dam gets delayed, if a motorway gets delayed, if a cement factory gets delayed, you know, the productivity gets delayed, and you know, the escalation takes place. So basically, starting from dispute avoidance, once it's okay, now you're stuck, dispute resolution, alternate dispute resolution mechanism in place, so that, you know, this takes care of it. And I'm sure, you know, the patronage of judiciary and their endorsement of the process will give respect to this mechanism. And finally, when the people of the country would know that going to the courts, once they have to go through these steps, you know, and whatever legislation, I'm saying the Act covers that, but whatever legislation is required, inshallah, we will take care of it. Let me tell you that when I was sitting in the assembly, we put together a caucus of engineer parliamentarians. Now, right now, in the Senate there are some engineers, in the Parliament there are some engineers, in the Provincial Assembly there are some engineers coming out of different parties, you know. So we have developed a caucus, at least on engineering policies, on technical issues. 2 plus 2 must come out 4. If I give a result of 5 or you give a result of 3, both of us will be embarrassed. So that's how we are engaging the parliamentarians also, and that's how we are hoping that the judiciary will endorse, and the engineers, the technical people, and from all mechanical, electrical, electronics, there are 32 disciplines out there right now in Pakistan. So that way, that enhanced with this help from the Chartered Institute of Arbitrators, whatever learnings we already have, and that would be enhanced, and I'm sure we will be able to fulfill that responsibility.
Thank you very much indeed. Thank you for the questions. I thank all my panelists for their contribution, and I thank you all for giving us the opportunity of presenting. Thank you.